The next thing I would like to talk about is the restriction on the transfer of shares. So it's said that when you go to speak to a lawyer about marriage, he talks to you about divorce. Well, the same really applies to a shareholders agreement and the transfer or the sale of shares. Typically, in a family business, you want to control the transfer of shares. I suppose that's important whether it's a family business or not. Okay, but complications can arise where there are family groups within the business that want to impose restrictions even within the family group. And this brings up the question of whether or not shareholders have to work in the business, whether in-laws can be shareholder or should they be excluded as owners, and that will all depend on the business philosophy. I find that in a lot of cases, advisors, lawyers, and accountants are making some of these ownership issues exclusively tax-driven, and although the tax component of that is an important issue, I think we do have to factor in the business philosophy of the family and try to marry that with income tax decisions, and hopefully it's a win-win. All right. Now, under the buy-sell rules, we typically deal with three types of situations. We deal with sale of by one family member. I mentioned briefly before about a drag-along rate. We'll talk about that in a second. The second is family members. So, one can go to that from one family member or family member. The company that's not ready to share and the majority was typically there's a with very generous financing terms. The second scenario relates to the sale of the entire business by all the family members. Typically, we will see a very, very high voting threshold to approve that type of scenario, and perhaps 90% or more, and maybe even unanimous. So my 2% ownership could, in fact, stop the sale of the entire business if to a third party if that's how the agreement is structured. So we need to be very careful when we're crafting that type of scenario. The third possibility that I mentioned is a forced buy-sell or a shotgun. For those that aren't familiar with the shotgun clause, it is usually structured such that if one of the shareholders wants to exercise the shotgun, they need to make an offer to purchase the other shareholder out. They usually provide for a purchase price and whatever the terms are. The other shareholder has only two options. They can accept that offer, or they have to buy the offer out on those same terms. So one of those two ends up with the company. It's an extremely harsh provision, and in any type of scenario, whether it's a family business or not, a person with deeper pockets than the others may have the potential to abuse this provision, meaning that they can probably get the corporation for a cheaper price because they know the other side can't come up with even a lesser price. But it is a mechanism that creates a resolution to a dispute. It's typically not exercised lightly, but as I mentioned before, it's very harsh, and it needs to be used with very, very much care. And I have to say that I've only included it in a very, very few number of family business shareholder agreements. There's pros and cons to that.